Human Rights Defender. The Office of the Human Rights Defender is an independent agency created by the law on human rights defender in Armenia, whose main purpose is to protect the human rights and fundamental freedoms mainly violated by central and local government agencies and their officials. Historical background. The word ombudsman has Swedish roots and the literal translation means grievance person. This word in its modern meaning was first used by the Swedish parliament in the 19th century when establishing the office of Justitieombudsman. This office was responsible for defending the citizens when they had issues with the government. In 1697 the Swedish king Charles XII, who dedicated the first 17 years of his governance to wars, hence was mainly out of the country, established an office called the King's Highest Ombudsman. The main job of the office was to confirm and consistently check that all the governmental workers were acting according to the king's rules, while he was away from Sweden. However, this office was closed when the king returned. Human rights defenders operate all over the world, independent of whether the state is stable or not due to internal conflicts, non-democratic one or has a strong democratic practice, economically developing or not. The defenders' role in a country is always crucial. They seek to promote and protect human rights in a context of a variety of challenges, including HIV, AIDS, development, migration, structural adjustment, policies, and political transition. Post-foundation history. So let's speak about foundation of this post in Armenia. The Office of the Human Rights Defender of the Republic of Armenia was founded in the beginning of 2004 by the law of the Republic of Armenia on the Human Rights Defender signed by the President of Armenia, Robert Khachatryan. To be considered as a candidate for the position of the Human Rights Defender of Armenia, one must meet the following criteria. Be an Armenian citizen for minimum 5 years, have lived in Armenia for the past 5 years, have minimum age of 25, as well as having sufficient knowledge and experience in the defense of human rights field. The National Assembly shall appoint the defender by a vote of more than 3/5 of the general number of deputies from candidates nominated by the President of the Republic, 1/5 of the National Assembly deputies. He/she shall be appointed to office for a term of 6 years with not more than 2 consecutive terms. After the appointment, the defender must take an oath. Human rights defenders history in Armenia. Armenia had only 3 human rights defenders. Aris Berberyan, who was the first human rights defender in Armenia and who was appointed by the decree of the President of Armenia, Robert Khachatryan. Levon Ghazaryan and current defender Karen Andreasyan. Power. Main points. The defender is independent in executing his/her powers and is guided only by the Constitution and the laws of the Republic of Armenia, as well as norms and principles of international laws. The defender is not subordinated to any central or local self-governing agency or official. After discussion in 10 days, the result about the complaint are being given to those central or local self-governing agencies or their official whose decision or acts idleness are being complained. The mentioned is obliged to send his position and clarifications to the defender no later than 15 days after receiving the result of investigation. This deadline can be extended by the defender. Who can apply non-discussable complaints? Any individual, regardless of their nationality, citizenship, place of residence, sex, race, age, political and other views and capabilities can appeal to the defender. Persons who are under arrest, in preliminary detention or serving their sentence in penitentiaries, as well as persons in other places of coercive detention, also have the right to appeal to the defender. The defender sends the copy of the decision to the applicant as soon as possible, but no later than 30 days after receiving the complaint. The defender does not discuss the complaints, which have to be solved only by the judicial order, as well as stops the discussion of the complaint if, after starting the discussion, the interested person submitted a claim or complaint to the court. After receiving the complaint. After the discussion of the complaint, the defender must accept one of 5 decisions prescribed in the law on the Human Rights Defender of the Republic of Armenia. The state agencies after receiving the complaint. Central or local self-governing agencies or their officials who have received the defender's motion in 20 days is obliged to inform the defender in written form about the undertaken events. The deadline can be extended in agreement with the defender if necessary. If necessary, the defender can present special reports to the President of Armenia and to the National Assembly. The defender can publish in mass media special information about the central or local self-governing agency or official who failed to respond to their motion and did not comply or only partly complied with the requirements of the motion, together with the responses of the central or local government agency or their officials to the decision of the defender and motion if all other means of resolving the issue through state authorities have been exhausted. Restrictions and limitations. Besides having different powers and zones of influence, human rights defender has also some kind of limitations and restrictions. For example, he cannot hold any state or other office or perform other work for compensation except for scientific, pedagogical, or creative activities. Be a member of any political party, nominate his or candidacy for elections, participate in pre-election campaigns. In addition, the defender cannot intervene into judicial processes, publish any personal data without permission of the complainer. In addition, the defender's decision cannot hinder the person from protecting his or rights, freedoms, and legal interests in other by other means not prohibited by law. Defender's immunity. Human rights defender has immunity like deputies of parliament. Defender cannot be prosecuted or hold liability because of the actions he/she did on their post, including the opinions expressed in National Assembly. He/she cannot be prosecuted, detained, or arrested without permission of National Assembly. Annual report. Every first quarter of the year, human rights defender should make a report to President of Armenia in first spring session in National Assembly, but in some exceptional cases he can make unscheduled reports. Termination. Defender's power shall terminate 6 years after his oath, but there can be some other cases when termination can be done prior to the end of the 6 year term. Here are some examples. For example, when he loses his citizenship or repeats his resignation letter to National Assembly, or in case of defender's death. Famous cases. There are some famous cases related to the sphere of human rights. We illustrate 2 of them. You can find those articles in the official website of the Human Rights Defender of the Republic of Armenia, as well as in our wiki page. So that's all. Thanks for watching. You can learn more in our wiki article dedicated to the Human Rights Defender of the Republic of Armenia. Our group members are Aris Berberyan, Levon Ghazaryan, Razmik Khachatryan, and Yura Shahnazaryan.